How do you make sure that you, your estate, and your spouse doesn't get saddled with unnecessary state estate taxes? You see, I've emphasized state. The reason for that is, and as I mentioned earlier, we serve clients in Washington State and in Idaho. Well, Idaho doesn't have this concern because Idaho does not have a state estate tax. So Idahoans are concerned only with the federal level, which is over $12 million per person. So if you have an estate of over 12 million and your spouse has an estate over 12 million and you live in Idaho, definitely you are going to want to see an attorney, a taxable estate attorney, who will make sure that you employ strategy so that you don't have to pay any federal estate tax if, for example, you have 24 million and you both are killed in an accident. That really is not what we're going to be focusing on today. But I did want to point out that if that is a value of your estate, you want to have an attorney with tax expertise, making sure that you're not paying unnecessary federal estate taxes. So let's focus on Washington State, because unlike Idaho, Washington State does have its own estate tax. And the level of that, what we call a credit exclusion amount, meaning what can pass free of any state estate taxes, is $2.193 million. I know that's a really weird number, but that's what it is. So let's say you and your spouse have more than 2.193 million. It doesn't have to be, double that. It doesn't have to be triple that. Just say you and your spouse have more than 2.193 million, but less than 12 or 24 million. You might be surprised that you have that much. A lot of people, frankly, are, especially when they look at how their investment accounts have done and what their real estate now is worth. And people that don't consider themselves rich at all have a taxable estate from the Washington perspective. So what can you do to protect assets for your spouse and also for your beneficiaries after you're gone? So the best or easiest planning that you can do is have a will that includes with it a certain type of trust. It's either called a credit exclusion trust, a bypass shelter trust. All of that lingo means the same thing. And let me explain how it works. So you and your spouse each have wills that contain these tax protection trusts that I just described. You're a Washington resident. Let's say that you and your spouse have $3 million and one of you dies. If you don't have a will with the tax protection trusts in them, let's say you die, your spouse inherits from you. Together you had a $3 million estate. When you die, because you are married, there is not going to be an estate tax imposed. But your spouse has now inherited $3 million, not just their share, but your share. And if your spouse passes away with $3 million, there is going to be Washington state tax, estate tax imposed on almost $1 million. That's a lot of money to pay, and be it starting at 10%, going to 15% to 20%. There's a sliding scale. Let's just say it's 10%. That's paying an extra $100,000 on the second spouse's death, all because they didn't have the right kind of wills in place to make sure that when the surviving spouse died, that there wouldn't be any estate taxes paid to the state of Washington. So if you have what we call an I love you will, which means everything goes out right to my spouse, no protections, no trusts. Or if you have a community property agreement, which frequently people do have in Washington that says, on my death, everything just goes to my spouse easily without the need of probate. Really simple. Yes, that will accomplish your spouse inheriting everything from you, but they will inherit it without any protections against myriad risks, including the very real estate tax that will be imposed on your surviving spouse's death if they do nothing further to, for example, give away their money, which oftentimes people aren't inclined to do during their lifetime for a lot of reasons. So, $3 million estate, what should you do? Have a will that has in it these trusts that I talked about, the tax protection trusts. So what it says is that on the death of the first spouse, their share, their 1/2 of this $3 million combined estate is going to pass through their will into this tax protection trust. How does this work? What does this mean? When I say pass through their will, that means there will be a probate. There will be a probate process, and that will cost money and legal fees, because I don't recommend that you do it yourself. You can try, but I don't recommend it. So there'll be a probate. The attorney will help you. The $1.5 million will go into this tax protection trust for the benefit of your surviving spouse. This trust is called a bypass or credit exclusion trust because what it does is it captures the decedent's credit exclusion amount. Remember I said it was $2.193 million? So their 1.5, their half of this $3 million estate will go into this protective trust for the surviving spouse and for ultimate beneficiaries. Okay, so this trust is set up. 1.5 million is in it because the first spouse has died. What happens when the second spouse dies? When they die, all that they have in their own estate, their own ownership, is just their 1.5 million. The 1.5 million that was the first spouse's to die is in this trust. And because it's in this trust, it will pass on the second spouse's death with no taxes imposed on that 1.5 million that's in the trust. And because the surviving spouse only had that, their share, their 1.5 million, that's under the Washington amount, which is 2.193. So by having all this plan set up with the tax protection trust in the wills, the estate passes and there's zero estate taxes imposed, as a contrasted to perhaps 100,000 being imposed. So by just some very basic planning in your wills to have these tax protection trusts, you are going to ensure that there is going to be no taxes imposed on either the death of the first spouse or the second spouse. Nobody wants to pay taxes beyond what they need to. I mean, that just makes sense. So why pay an extra tens, if not hundreds of thousands of dollars to the state of Washington if you don't need to do so? So that's the number one planning technique to protect assets for your spouse and for your beneficiaries. Have a tax protection trust in your will, in your estate planning documents, if you have an estate that is beyond the 2.193 million. There's a lot of other strategies that I'm not going to get into today. There's, gifting you can do during lifetime. There's charities you can give to. There's irrevocable trusts you can do during your lifetime. There's all sorts of various other estate planning techniques. I'm not going to get into those. I just wanted to share with you a very simple estate planning technique to avoid paying Washington any taxes that you don't need to pay them.